In an announcement which could pave the way for a landmark change in one of the most controversial laws in the country, the law on sedition, the government has said that they will reconsider key provisions of the law. They have said this to the Supreme Court just a day ahead of this law coming up in the Supreme Court, where a judgment or an order was possibly likely on this. There have been lots of views on sedition. There are many who believe that it is a vestige of the past. It is a colonial law being used by several governments across the country to harass those who speak out, who dissent, who are journalists, who don't conform to what may be a government opinion. There are numerous instances of how prosecution in sedition cases has been extremely low in terms of a success rate, in terms of prosecuting individuals who do in fact say something seditious and it is legally maintained that there was sedition involved. So prosecution is low. Multiple examples of cases being filed on individuals, those cases being tossed by various courts. And now the government, after the Supreme Court made several references on this particular law, has said that it has had a relook. Now this relook comes just about 24 hours prior to this coming up in the Supreme Court. In a very important announcement, the government has said, I'm going to read out a few lines. The Prime Minister has been cognizant of various views expressed on the subject and has also periodically in various forums expressed his clear and unequivocal views in favor of protection of civil liberties, the respect for human rights, and giving meaning to the constitutionally cherished freedoms by people of the country. Later on it says, the Prime Minister, at a time when our country is marking Azadi ka Amrit Mahotsav, we need to, as a nation, work even harder to shed colonial baggage that has passed its utility, which includes outdated colonial laws and practices. In that spirit, the Government of India has scrapped over 1,500 outdated laws since 2014-2015. Well, joining us now, my colleague Sukirti Dwivedi, who's been tracking this now for years. Sukirti, it is interesting that the government would decide that it wants to relook at the law on sedition at a time when an order was expected tomorrow. And there was no guarantee at all that the order was necessarily going the government's way, particularly since some of the utterances of the Supreme Court had suggested that the law may have been misused.
Well, yes, Vishnu, you're right. Because also, if we look at the pattern and the way the centre has been arguing in court, firstly, the matter has been going on for over a year. Firstly, the centre kept delaying when it would file its response. Then it filed a written submission saying that there is no need at all for any kind of reconsideration or re-examination of the law. All of these aspects pertaining to fundamental rights, and all of those have already been examined by a 5-judge constitutional bench earlier. So there is no need for the court to undergo all of that again. But now the centre coming out with this particular affidavit pointing out two factors. One, the Prime Minister's vision on the entire issue, and then 75 years of independence. And as you read those lines from the affidavit talking about civil liberties and human rights, and now urging the Supreme Court to give the central government more time so that they can carry out this entire re-examination exercise.
But Sukirti,
and of course, the timing
going
of
beyond
it all
the legal
matters
process,
because tomorrow the Supreme Court is set to hear all of these.
Sukirti, I'm just saying, going beyond the legal process itself, and obviously changing the law or dropping parts of the law, that's going to take time. It has to be cleared by Parliament, etc., etc. When it does happen, and the indicator is that it will, this is going to be a stirring victory for journalists, for those who believe it is our birthright to dissent, for those who believe that they have a right to speak out against anything they want, the freedom of speech and expression. This is a huge victory for the core of our Constitution. Isn't that what this is all about?
Well, absolutely, Vishnu, because if you look at the petition itself, which was filed by the Editors Guild of India last year, when after the farmers' protest violence, several journalists faced sedition FIRs, including very renowned journalists like Mr. Rajdeep Sardesai or even Congress MP Shashi Tharoor faced sedition FIRs just because of the things that they had tweeted about the farmers' protest violence. And the petition filed by the Editors Guild of India said that this is not how things function in a democracy. This is not how freedom of speech and expression should be in a country where journalists just want to perform their duty. How will they do it if anything that is critical of the government is going to end up with a sedition FIR, then how will any individual feel free to express their voice, feel free to express their feelings on any matter that they think is relevant. So all of those, you said, as you mentioned, those basic freedoms, those fundamental rights, those have been in question because of the way sedition law has been misused so far. In fact, even Attorney General K.K. Venugopal had agreed that there have been cases of misuse. However, the argument that he was making was that those can be addressed on a case-to-case basis rather than re-examining the whole law. But now, even the central government seems to agree that re-examination of the entire law is needed, and the exercise for the same will be carried out by them.
All right. Well, joining us now, Shahdan Farasat, the advocate in the Supreme Court. We're also joined by Deshratan Nigam, who's also a senior lawyer. Mr. Farasat, let me come to you first. I think the bottom line over here is that this is, all about our identity as a democracy where the freedom of speech is protected. If the government, perhaps belatedly, but still chooses to change the law, it protects one of the most important aspects of our democracy, the right to dissent, the right to free speech. How important is this step announced by the government today?
Yeah, so firstly, I think the government is not doing this out of any goodwill. I think the writing is on the wall. The matter was to be heard today on an issue of reference to the 7 judges. I think the government's lawyers have quite rightly read the court that this sedition law would have been held to be unconstitutional. So it is not out of any goodwill that the government is doing. It is just that instead of the court holding it to be unconstitutional, they are coming out and trying to take the credit for it. And that shows from the affidavit, the kind of affidavit that has been filed. It reads more like a political speech with the Prime Minister's name in it and his vision. I have not seen a court affidavit naming a Prime Minister and his vision. Government affidavits are normally as to what is the position of law. It sounds more like a political speech. But be that as it may, it is a welcome move. But what are the terms of that move? In terms, is it a straight out repeal, or is it going to be a modulation so that actually the cure will be worse than the disease? We don't know.
Right.
We don't know if they will modulate it and amend it, but leave a smaller offense there. We don't know. So my view is that unless it is very clear of what the government intends to do and the timeline in which it intends to do that, I think on something as general as this, the Supreme Court should not defer the hearing. They should go ahead and hear it fully and take a call on the constitutionality of the law.
Right.
Anyways, the constitutionality of the law is completely different from if the government seeks to repeal it.
Yeah.
But if the government were to commit, yes, we are repealing it altogether with a clear structure and a timeline, we intend to move it in this session of the parliament, then that's possibly a different story. But what I've read is very general. Okay. On the second point, that is this a win? Yes, of course it's a win. But is this going to be sufficient? I don't think so. I think all kinds of laws, not just 124A sedition, even something simple laws like hate speech are being misused against political opponents, minorities, a whole range of groups, dissenters. So you see, you can weaponize anything. You can weaponize a simple provision which has just 3-year imprisonment if the police so chooses, or if the political master of the police so chooses. Therefore, 124A going is of course welcome. But is it going to be sufficient? Of course not. I don't think we should delude ourselves that this is going to change the ground level situation.
No, I get the point. I get the point. I would suggest that it is still a very welcome first step. But I take the point that you're mentioning, Mr. Farasat, that we don't know how it's going to eventually pan out. Deshratan Nigam, did it actually need the Prime Minister to intervene when we have known for so many years that prosecution rates under sedition cases are minimal? That there has been a concerted effort in so many cases by people filing FIRs in different courts in the country to get after someone. Many of these are political cases. Why did it have to boil down to this? Couldn't this have been removed earlier on, or changed or modified?
Vishnu, let me go step by step. The law as the wording of the law as it stands today is of a British era. However, the interpretation of that has been changed by the 1962 judgment of Kedarnath and has been made suitable for an independent India, where they have clearly said that merely disaffection against the government, which we in Hindi call ashantosh, or speaking against the government, was the pre-British law.
Right.
But the present law, how it was interpreted by the 1962 judgment as somebody by spoken words or written words intends to create violence or creates violence. So that is a distinction the Supreme Court has already drawn down by a 5 judges constitution bench. Now, what could have happened in Supreme Court? The 3 judges bench could have referred it to a 5 judge bench because it was the 5 judges constitution bench which had passed. So that bench could have created a doubt whether this law is to be removed or not to be removed, as in the light of Kedarnath Singh's judgment. However, since this was even a stage, nothing could have happened. The law was not going anywhere in near time, even by the Supreme Court. 5 judges bench, then it would have been referred or not referred to a 7 judges bench. So this is the position as of now.
No, but sir, you're talking through the process, Mr. Deshratna Nigam, which may or may not have taken place in the Supreme Court. What I'm trying to ask you is that this was clearly being misused. There are umpteen cases. It's all been listed in the plea in the Supreme Court. Why did it need to come down to this? Why couldn't it have been removed earlier?
So let me tell you, reconsideration and relook means it will go to a thorough process of all data analysis, whether what is the percentage of misuse, whether the law is required in view of Naxalism, Maoism, or certain terrorism going on in the country, or various other aspects have to be taken into consideration as of now. Misuse of law is rampant in almost every aspect of the law which has been made in this country.